Welcome to our ongoing YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal. And in this particular YouTube video, we'll be discussing the aspect of termination and severance pay for construction employees, and with a particular emphasis on those working in the province of Alberta. Now, one of the things that construction employees do when they get terminated is they've either spoken with other people, they've looked on the internet, and they realize that the Alberta Employment Standards regulations specify an exclusion for construction employees from receiving termination pay in lieu of notice. Now, this does not necessarily apply to everybody in the construction field, but a lot of the laborers and individuals who are working out in the construction sites, they are excluded from one aspect of pay at the end of their termination, and that is termination pay in lieu of notice. And that's a statutory provision. But there's a very distinct and separate payment that is typically due to employees upon their termination. And it's not a statutory payment, it's a payment that's due pursuant to the common law, and that is severance pay. And severance pay is derived from common law, is not derived from statute, and as such is distinct. And many of the courts have clarified and stated the distinction between the two, and the fact that in certain circumstances, construction employees are entitled to severance pay, even though they might be statutorily precluded from receiving termination pay in lieu of notice. These two matters are distinct. And some of the cases which specify how severance pay was denied are very unique in their terminology and in the facts and circumstances of those cases. So you have to understand that even though you might be excluded in one area by statute, it does not translate into exclusion across the board. Now, the challenge with common law payments is that, and in the construction industry, is that a lot of people in the construction industry, and the way that construction companies approach it, is that they don't want to give anything. So they take a hard stance on this stuff, realizing full well that it could be very costly to pursue litigation to recoup one's entitlement to severance pay. And as such, they take a hard stance at the beginning, and they want to take that position because otherwise, should they not take that hard stance, they would be repeatedly and consistently be required to pay severance pay, because then it becomes a standard flow as to what is being paid. Now, do not get totally disheartened on these situations. Don't just say quit your research, quit your looking, not even discuss it with lawyers, because it may seem burdensome, but there are tactical strategies, there's opportunities available to you, and that's what you need to talk to a lawyer about, the right lawyer. So what you'll find is, first of all, you'll hear these stories about how, well, we can go pursue severance pay. Construction companies are going to be very ambivalent to it. They're going to push hard against it. And the cost of pursuing this litigation can be quite onerous. And oftentimes the lawyers talk to you about the fact that they don't want to be covering the cost when the chances are somewhat less certain than in other cases. And they understand that the construction companies take a hard position on it. That may well be true. However, the key is to ascertain tactical legal advantages, tactical opportunities within the individual's and the company's pay system that may well lead itself to providing the lawyer with the means with which to effectively advance a case as against the construction company. And oftentimes it's a case that goes beyond your individual severance pay. There may be other elements, and those elements need to be drawn in. It takes a lot more review, deciphering, investigation, but there is the distinct potential for opportunities to challenge construction companies following one's termination. So even though termination pay in lieu of notice is barred by statute, that does not mean you are prevented from using the legal tools available to yourself to get various forms of payment out of your former employer in the construction field. What is necessary, however, is that you have the right lawyer who understands how to approach the investigation and pursuit of what you might well be entitled to, and how to definitively challenge these construction companies so they understand that they will not succeed in preventing you from getting payment following your termination. And that is simply the reality of the situations. The situations are designed, and it seems designed when you first look at it, to prevent you from getting any payment when you get terminated from a construction company and you work in the construction field. But that is only the farthest realm. There are opportunities. The key is to get the right lawyer, work with that lawyer, investigate, and find the means by which you might pursue the payments that are legally due to yourself. So we wish you all the best. We understand, as always, when it comes to being fired, laid off, or otherwise terminated from a job, it is a challenging time, especially when you've put in so much hard work and dedication and you find yourself let go for no particular reason, but for the company's economics. And now you're struggling to determine what you want to do and how you should deal with it. There are ways to deal with it. The road is not closed just because you worked in the construction field. There are opportunities, but it's a matter of taking the right approach and knowing how to approach these construction companies advantageously from your standpoint. So we wish you all the best of luck in these pursuits. Thank you.